Welcome to the Exit Strategy, your no bullshit guide to divorce with the experienced attorneys from New Direction Family Law. Unfiltered discussions to help you move from victim to victorious and from bitter to better.
Hi, Elizabeth Stevenson with New Direction Family Law.
And Sarah Hink, also with New Direction Family Law. We have Cam, also
Cam
with New
Hines.
Direction Family Law.
Yes.
Not an attorney, but she coordinates us getting to the podcast and our topics, so we couldn't be here without her.
That's absolutely true.
And I work a lot on the client side of things too, so I can
Yes.
I ask a lot of the same questions that clients would ask because I'm not an attorney. So
Yeah, especially their first thoughts and questions when they're reaching out to an attorney, which are very valuable, especially
Absolutely.
as attorneys who, just go to the law part when we start talking to clients.
Correct.
Yes.
So what are we talking about today, Miss Inc?
Oh, that's me.
Yep.
We are talking about preparing our clients for their testimony. So
Correct.
you have your court case coming up, discussions of settlement didn't work out.
Yep.
It's custody maybe it's property or financial, like spousal support. There's lots of different, topics that might find you in court to
Correct.
take your testimony. It's always funny when I have clients ask me, so do I have to testify? Do I need to be there?
Yes, that would be helpful.
A lot of times I'm like, you know what? It is like Law and Order. Yes, you do need to be there.
It is sort of, but it is kind of like that. I mean, you have to
Yeah.
show up and, it is a courtroom and there's a bench and there's the judge and the clerk and there's
very
a
rarely
table.
jury, right? Just
Yeah,
the
you
judge.
can't have a jury trial on alimony, like alienation of affection or something like that.
Those are
but-
really the only two areas.
Yeah. And so, sort of the basics are the layout is there's a table in front of the judge. You sit with me, my client sits with me, and then the other side's on the other side. So you're pretty close in proximity.
Mm-hmm.
The big thing is, I tell people, is it's an open, we have open courts. So you're going to be spilling all your private stuff up there, and there can be these people in the audience, but they don't really care about you because they got their own shit going on.
No. And, some of my clients, I recommend if they seem really nervous about it, I go tell them to go to courthouse
right.
and go observe other trials. I think it's a good experience if you're really nervous about it to see what happens. Because we do the family court cases all on the same floor in Wake County. So just pick a day. There'll be
Well, go to your
hearings.
judge. Yeah, we have assigned judges. So go to your assigned judge, and you get sort of a feel of their personality too on that. So
For sure. That's good
Go
experience.
do your homework.
absolutely. I mean, something as basic as what do I wear? We talk a lot about testimony and exhibits, but the basics are making you feel comfortable, and that's what you don't have to wear a suit. Wear a collared shirt, wear a skirt. Do not wear what do I call them? Daisy Dukes.
Daisy Dukes. Yeah, don't wear Daisy Dukes.
Don't wear Daisy Dukes. Don't wear a tank top.
Don't have your cleavage out.
Yeah, don't wear a hat.
hats.
Just don't do that. Don't wear flip flops. That kind of
Yeah,
thing.
I mean, I pretty much just to simplify it, tell my clients that you're there to tell the court and the judge your story.
Correct.
Your
That's
side of the
exactly what it
story.
is. So be comfortable while you're doing that.
Make eye contact with a judge
Right.
if they're listening. Sometimes I'm like, are they even
Well, they have a computer up there. I think they do listen, but they're typing in their notes too sometimes.
Yeah,
But the process, I think, too, is important to know how it works. Is that if you're the one that filed the motion, whether you're plaintiff or defendant, you're going to put on your evidence first for the most part, not contempt. But that's for another day.
Yeah.
And so you're going to call all your witnesses up there. But each witness gets a direct examination, and then
The direct is from your attorney.
Correct.
So that'd be your attorney
Right.
asking you questions.
and those are open-ended. I cannot. They're who, what, why, when, where.
Yep.
Not
That really is you telling your story.
That is. So you need to review your notes, your journals. We try to send them the exhibits ahead of time so they can review those because you
Have
don't
their
want
facts straight.
right. So don't. Well, and when did that happen? I don't remember. It does not seem credible.
No, it never does. And the other side, if it's a good attorney, will pick up on that and call you out for it.
Correct.
So you don't want to clam up so much that you do not give those full answers to your attorney. So I know there's times where I've gone over testimony beforehand, but still the client just doesn't have the personality to really open up on the stand. And it's like pulling teeth, just trying to get them to
Right.
say the information you want them to and need them to.
Or it could be just the opposite, where
Please stop talking.
my advice is answer the question only.
Yes.
If I need more information, I'll ask you for more information.
And
right?
and I remind them about we are timed.
And I say that to them. Now we're in a time crunch, so I'm gonna point you in this direction.
So what that means, for instance, is on a temporary, hearing for custody in Wake County, you get 2 hours. And so your side gets 1 hour, and they are literally stop clocking you. So if you have a tendency to ramble, you're going to eat up all of your time. It's not going to be relevant. You're just like all of a sudden talking about something that happened on 4th of July 5 years ago at your grandma's house. And your attorney is like shaking their head, telling you to wrap up. Well, you got to pay attention.
Right. Because they'll cut you off. You know, we're done. So, and then the other side, the defense attorney who represents the other party gets an opportunity to ask you questions. And what happens when that happens, Sarah?
I was going to expect it to be a bit more aggressive. They're going to ask you direct questions, yes or no questions. You don't
Isn't
always,
it true?
Yeah, isn't it true?
Wouldn't you agree with
Isn't
me?
that right? So true or false?
And they want to lead you down a path. They'll get you sometimes to answer very easy questions. And you're going, la, 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 la. And then they ask you a question, and you're just answering yes, yes, yes. When I know in my head, that is not what you told me, and I know that's not true.
Right. So I always tell my clients, take your time,
Right. Take a breath.
listen, ask them to repeat the question. If you
If
need
you don't
to.
know, you don't know.
Yeah, don't make up answers.
Yeah.
That happens to people. I think people have a tendency to
Seem
do
to want
that.
to answer a question.
Especially people pleasers, if you have that personality. Like,
don't
don't
know
make up an
anyone like that.
answer. Don't try to guess what the answer is.
Right.
I don't know.
Right. Or if you don't
know.
remember, you don't remember.
That's not right.
Right.
That's not how I remember it.
Right. Exactly. And then, and you get a chance to explain your answer. Just answer yes or no first if it's a yes or no question, then explain your answer. And then we get a chance to sort of what I call clean up. Come back and clean up,
Clarify.
and anything we need to sort of touch on that you may need a little more clarification on.
Yep.
And so we're done with you. And then generally for custody, it's character witnesses a lot for parents.
I served as a character witness once.
I did.
Nice.
Yeah.
For the one brother.
Yeah. And so, you're up there saying what a great dad they are. My philosophy is do not get up there and bash this other. That's not the point, is to bash the other parent. The point is to show what a great parent you are, put you in the spotlight. We're going to get to the negative part of it in his testimony.
Only if you actually witnessed an act that was not.
Right. We know he's an asshole, but that's not what we're here about today.
Yeah, unless you witnessed an actual asshole event that you can testify to.
Right, but they can be neighbors, they can be parents, they can be teachers can come in and testify. Oh, she shows up all the time. She's a parent volunteer. She's the one that picks up every time.
New spouses.
When have you ever seen Dad? I think I saw him in the office one time.
Yeah.
That's a great witness. They're not testifying about these are not testifying about who should have custody. That's not their job. Their job is to give facts about who takes the better care of the child, I think, right? And then there are expert witnesses. And so what's the difference in like a therapist coming to testify, let's say?
So a therapist can testify as an expert if you get them to be an expert through your foundation, but they can also just be a lay witness as well.
Correct.
So a lay witness is someone that's just going to testify of what they have observed and their actual, interactions with people. And then an expert witness is going to have testimony put forth that's based on something in their background. If it's a therapist, their actual knowledge of what they can actually make recommendations or tell the court what they observed and what they think based on what they observed, and give actual, more than just what they saw with their own eyes.
Right.
And because the child said this, I have concerns about dad.
Right.
So that's the difference, really.
Right. And the other thing that frustrates clients a lot and what we talk about in hearing prep, that I get, they'll pass me a sticky note or they want to say this. It's like, I can't, there are rules of evidence. And so there are certain things that I can get in and let the court hear and certain things I can't. Like, you can't tell me what your kid said to you unless your child is coming to testify, unless there's an exception of like a hearsay exception. And that's very frustrating for people. And so we practice that testimony. Well, and can you share with me what was, knowing your child as you do, how would you describe her demeanor? That's sort of, and that's why you do hearing prep. So they understand the rules of evidence and understand our frustration too, and not being able to get certain things in.
Right.
Documents, or, I get sticky notes. Ask about this. It's like, I can't because, that person isn't here to testify. And it ties your hand sometimes, and it's very frustrating.
Although I think the note I get written the most on those notepads, that's not true.
Yeah, that's bullshit.
Yeah.
And speaking of, the other point is, we will give you you get a legal pad. You sit at the table with me. You got a pen. But do not, if you're going to write me a note, do not scribble it.
Yeah, and don't talk. And I tell them before them, like you write whatever your thoughts are down.
Right.
Write them down because I'm listening to whatever's going on in court. And if
Correct.
you're talking to me, it's really hard to listen to two people. But I can't multitask with reading and listening, just not listening with two ears at the
Correct.
same time.
Correct.
So that's why you get the notepad to write those notes down. Can help with cross-examination, but don't be surprised if I don't ask any of the questions you're writing down for me to ask the other side.
Sometimes I do because there are some that hit and some that I would think didn't but did. So I don't have a kind of a problem asking a lot of questions that clients ask me to ask. And the other thing that judges hate is the rolling of the eyes, the harumping. And that happens more with people that are there as character witnesses, especially like if your new spouse is there or your mom's there or your dad's there. You know, they're invested as much as you are, but you can't show any of that emotion in court. You just can't. Mm-hmm. You know, it's okay to cry on the stand. I'm okay with that. Just don't lose your shit. You know?
Yeah. And, you know, think this court, the judge, they see families in there all the time, testimony, and they have their own bullshit meter. So you don't want to come off like too not truthful with your emotions.
Yes.
So just make sure that whatever's happening is just a real emotion just based on the topic that you're talking about.
Sometimes that's all we have is all the judge hears sometimes, especially in a temporary hearing because it's limited to an hour or two, is to look at these people that they have never met before and determine who is telling them the truth and who is more credible.
Yep.
And that's
got to be a little hard.
Are you kidding? Can you imagine?
Yeah.
I mean, and you're the fourth set of people he's had to do that with today.
Yeah.
And he's got attorneys or she's got attorneys in her ear.
Correct.
Arguing about whatever. You know, it's tough for the judges to do that. But people do lie on the stand, and they do get away with it, too.
All the time they lie on the stand. All the time. All the time.
And no, the judge does not throw them in jail for perjury.
No, they're not, even though you're writing perjury on your...
Yeah. Should they go to jail for that? I'm like, no.
But that, you know, it's just to hear you prep me, those are just some of the... One of them, again, is people lie all the time. You know, and you're just going to have to take it, and we'll have to do our best on cross to figure out how to deal with that.
Yeah.
You know?
And like you said before, I think there's a level of respect for when an attorney and their client do take that high road and just focus on the highs of them as a parent and, you know, obviously highlight some concerns of the other parent.
Well, yeah, absolutely.
But then if the other side comes in and it's just all dirt and mud, like really based on nothing but their own like feelings or taking things out of context. That's not going to look good. And the judges don't want to see that because in their head they're going, well, this person's probably, not a fun person to co-parent with over here.
Right, over here, exactly.
So that will really diminish your own argument inside if you just spend all the time in the mud on your case.
Right.
Hey guys, it's Cam with New Direction Family Law, and if you yourself have been through a divorce or you know someone that's contemplating divorce, then you know how important it is to make sure that you know your legal rights or your friend knows their legal rights and options to help develop the best plan for them and their family moving forward. At New Direction Family Law, we have over 80 years of combined experience protecting the rights of our clients in family law matters. We aggressively advocate, we aggressively support, and we absolutely educate our clients to achieve the best possible outcome. So if you know someone or you yourself are facing these questions or contemplating separation or divorce, give us a call to schedule an initial consultation today. You can reach us at 919-719-3470 on our website at newdirectionfamilylaw.com, or you can click the link in the episode description.
We use a lot of text messages. We use a lot of emails. And
For evidence.
So my advice is you better not send anything you don't want read out loud in court.
Yeah.
Because it will definitely be read out loud
Talk
in
about
court.
credibility.
Yeah, that's right.
What you said the other, other month.
Yeah. And so, we use iMazing and other, I don't want, because people used to just selectively send you text messages, the ones they wanted you to see. And then they're not in your exhibit notebook, but the other ones they didn't want you to see are in the defense's notebook. And so I want to see all of it. And you're going to have to be honest and upfront and send it all to us.
Yeah, so we know what to expect and how to defend the things that you said.
I don't want surprises. That's the worst feeling in the world. When a client testifies to something,
well, it's
and you don't know a thing about it.
I mean, to put together like an articulate argument and like when you're caught off guard, like by information.
No, you just sink down in your chair there.
But there's nothing wrong. I mean, I mean, it's hard. I mean, in my own separation, my ex was one of those that would write 4-page emails, and you want to. And my first response is, I need to answer all of that.
You don't
do it. Let them be the crazy one. But if you have a bad night and you call them out, then testify to. I always say, throw yourself on the sword and testify to it, and then explain why you did it, and say, I know that was wrong, and then you show from then on there wasn't another one like that. So that's okay. And we're all human.
And that's why we have to see all of it, because they might cherry pick the time where you called him an asshole, but they didn't show the text messages before where he just,
paraded you.
Correct.
Passive aggressiveness, just demeaned you, what have you. So that's why we really need to see everything that we can show what was happening.
Right.
Show the context.
Right. And you want to be upfront and honest about anything that's bad, that's out in the public, or marital misconduct, because they could bring a PI in there and show me something that you haven't told me.
And don't fake evidence, right, Elizabeth?
That's exactly right.
Elizabeth had some run-ins with some people who faked evidence.
Who were sending emails under other people's names, but didn't tell my client, didn't know about it, but it came out eventually. So don't try to help the person who's on trial by doing something like that.
AI is getting so sharp these days for all kinds of purposes. Someone mentioned the other day, like using AI to fake someone's voice and leaving a
Marco
voicemail
Rubio or so, it's like they did an AI of him to other country. It's like, it's crazy.
It is. It's going to be so difficult to start to filter through what's
to see what's real and what's not. Because you can do it with emails. You can set up bummer emails or whatever, and now you can do voice. This was a voice recording that they had done and spoofed and left a voicemail.
So all of us attorneys have to sharpen our
we got to sharpen our skills too. That's absolutely true. That'd be a good lunch and learn.
Trying to spot fake things out there that you might use in court, because that eventually looks bad on us.
Absolutely,
but we might not know.
But
sorry,
we went way off our topic.
So what I'm hearing is have some respect for the court, both in your behavior and how you're dressed.
Absolutely.
Yes.
Be truthful, both like with what you say on the stand and what you've shared with your attorney. Take a breath. Try to stay calm and be genuine to who you are.
Right.
Like own your mistakes if you've made them.
Absolutely.
Make eye contact with the judge when you can. And just give your testimony.
All you got to do is tell the truth and tell your story. And basically that's what it comes down to. And the judge can ask you questions, and they do a lot of times, And
the financials, I would say, for an equitable distribution trial or an alimony trial, it's real important to have that testimony. I think custody is just completely different. But for those financial ones, we want you to look at all the documents, be prepared, know what this document is, know what number we're looking at. There's so many times where, I've seen people in court and the opposing counsel didn't practice with their client at all, and they're like, what balance was it on this day? And they're like flipping through all these papers and can't read like a bank statement all of a sudden, and it's a disaster and it looks sloppy.
I agree.
So when it comes, it's not as we don't talk about the financial cases as much on here, but those are just as important to really be familiar with the documents. If you have to get an appraisal, be familiar with the appraisal. If there's business documents in there that you're absolutely not familiar with, to sit down with your attorney and learn what's important, what numbers to focus on, and make that case go as smoothly as you can for the judge, because those are the ones that gives the judges headaches.
Right, because they look to us to do the numbers. They don't want to do the mathing. They make us do the mathing. So we want to make sure we get all that evidence in.
Yeah.
And court could be long. You're there for 2 or 3 days.
Yep.
And if you're there for 2 or 3 days, it is rare that a judge is, if you're on Law and Order, you're either guilty or not at the end of the trial.
Right, at the end of the 30-minute episode.
Here, you can wait 3 months, 6 months. I've had to wait almost a year for orders. So don't expect, unless it's like a temporary order, to come out with a ruling that day sometimes. And that's hard for people. They've invested all that, and they want it over.
Yeah.
Yeah, and if you get a ruling, don't, slam your fist on the table.
Please don't. And don't try to talk to the judge and say, can I tell you? No. Don't do that.
I've seen some bad things.
I know. It's been bad.
Not on my client so far. Knock on the wood there. This wood. But I've seen some pretty... And the judges remember. I've been in a hearing.
They remember.
Like, oh, sir, I remember you from last time when you stormed out of this courtroom.
It's not a good sign. It's good if it's on the other side. It's good for you. But and the other end thing, and people can represent themselves. So if I'm representing my client, I think it's very important to make sure in the hearing prep you explain to them he can ask you questions. You know, even if there's a DVPO in place, he can ask you questions.
Yeah.
Do not bite back. Do not get mad. You know, just tell the truth. Keep because they're going to try to get you. They know how to push your buttons.
Yeah.
You know,
That's why you're not married anymore.
Exactly.
Probably.
right. Right.
Yeah.
So I think that's another important part. I can't think of anything. Do you do anything different? Anything else in a?
And like a trial prep experience,
Yeah.
I just, look over the exhibits to make sure they're
Right.
familiar with the exhibits, go over what potential exhibits the other side might have,
Right.
how to respond to the other attorney when they're asking you questions. Never interrupt the judge. They hate that.
Yep, they do.
And whenever there's an objection to stop talking,
Yep.
they don't like that either. So
What is it? What does sustain mean?
that means that whatever objection the attorney made is kind of granted, I guess you would say. Like if they object to hearsay, motion to strike, then the
So if
judge
the objection is made, stop talking.
stop talking, sustained, move on. The other attorney, whoever's
Right.
question
You
can
can't
move on.
answer that question. Right.
Right.
Right. So, and it's hard to. I mean, it's hard. I've never been a witness before, so I don't know what it feels like up there. But I think I would be nervous if I was up there.
It was a little.
Was it nerve-wracking?
Yeah, and it was maybe it was a quiet day. We were the only our crew were the only ones in there that day. Well, it was 2 days, and so, but I mean, you're kind of up there and you're on stage,
yeah.
and so you're sort of there is a little bit of pressure, but I had a chance to think about what I wanted to say,
Right.
and so. And think about what the other attorney was probably going to ask me, and was ready for that.
Oh,
so
good.
because I knew that they I was a character witness for a custody case,
Right.
and so I knew that they were going to poke at me at the fact that I don't have kids. So
Right.
who am I to speak, right? And so I was ready with that answer. So
Did they ask you that? Or say
Yeah.
anything about that? They
they're
did?
like, "Oh, but you don't have children, do
Oh my
you?"
gosh.
And
I would never.
I can sort of imagine who would ask you that question.
That's
Well,
insane. I always
I
try to
just-
be super nice to character witnesses.
I don't
I
know.
do too. Well, sometimes I do. Yeah.
I just sort of looked a little sad and said, "No, I haven't been blessed in that way."
Yeah.
a good answer.
And they
Perfect
didn't
answer.
ask me any more questions after that.
That's so ugly.
I love
would
that.
never.
Yeah. So we do hearing prep with our character witnesses. It's on the phone, but I just think it's malpractice to put somebody on stand and not have a conversation with them and to help them understand the process.
Yeah.
So,
Yeah.
yeah. There we are.
Ain't that some
Thanks for listening. Don't forget to leave us a review. You can visit us online at newdirectionfamilylaw.com. You can also follow us on Instagram at the Exit Strategy _podcast or email us at exitstrategy@newdirectionfamilylaw.com. We'll be back next week with more no bullshit content about life, divorce, parenting, relationships, and everything in between.